Any mentioning? Yes.
Item number one. My lord, one, I am appearing for the petitioner. My lord, this is that matter, my lord, where I have argued that in respect of the two co-accused person, the coordinate bench has been pleased to course the proceeding, and this revision is also arising from the self-same parties. Only the petitioner is different.
Yes.
And on last occasion, your lordship was pleased to direct me to hand over the copy of the judgment passed by the court
Yes,
to
yes.
the
Yes.
and an advocate who is appearing for the state to verify whether this person is standing in the same footing or not.
Yes. Who is for the state? Mhm. Yes. Yeah. Yes, yes. Item number one. What is your stand?
I have gone through the case diary, my lord. Recorded by the sorry of the company. Established. I do not find any specific component by the recent petitioner, Rahul Chow. He's standing on the same footing, with other two co-accused, whose prayer allowed all are executive, of the company,
Executive.
executive of the they were employee of the company, salaried executive of the alleged company, the accused number 225. Accused persons have been allowed, this is Rahul Chow. This is the judgment delivered by coordinate bench.
Yes. Yes. Okay. CAB for possible.
Since the decision of the coordinate bench is there, so I am not entering into the merits.
No, no. With pass order after going through with the judgment and case diary.
Well, if your lordship so pleases that there is something of which your lordship thinks that there is a distinction or something, then lordship might kindly grant me an opportunity of hearing, because
Sure, sure.
I did not use the supplementary and other things which I have used in that particular revision, village.
Here learned advocate for the petitioner filed judgment ke key reference ache a copy of judgment of CRR here near the with the consent of learned advocate for the state. Learned advocate for the state submit here filed submit filed case diary argument heard CAB.
They are standing in the same footing, village, and the situation is absolutely same.
We'll take up. I will discuss those facts in my judgment. I will discuss those facts in my judgment.
Observation was stated in the judgment, that is not in the case diary. That's why well, that happened because
no, I will not consider those parts of the judgment. Only same footing or not. That much I will rely. Your submission is also that
specific overhead.
No specific overhead.
Just stated in our case diary. Only on the basis of the case diary.
Yes.
Statement by
Your 2 points. You have submitted 2 points. He is standing on same footing as of the Jitendra Kumar. As of the Jitendra Kumar. The goal of Jitendra Kumar, and Rahul Chawla, there is no role. No role.
That is why they are standing in the same footing.
That is why that's all. I will reflect the same in my judgment. No role, no name in the Christian 161 statement, no name of the Christian and other poet. Only the partner of the Alok Chakraborty is naming the Christian.
Alok Chakraborty is the person.
Alok Chakraborty.
Alok Chakraborty is the main person.
He is the partner of the defective. Role is in the Christian, but other poet. I do not find their name only in the FIR and in the charge. But there are two things: one system statement and one season and one notice. The 91. Nothing in the system. What is role of the Uchala? What is the what is that? That's why I am submitting. They are both standing on the. Already, coordinate bench has decided this matter. So that everything discussed in the judge. The arbitration clause, the high court order, the civil suit pending, and there is no other detail regarding 420, everything could cover. Everything.
If you are not so pleased, the supplement we have used in that particular CRR, we can hand it over to you.
No, not. If record will.
Kindly grant me an opportunity, I'll satisfy.
Sure.
Item number 2.
Lordship, for the Lordship, Mr. Mukherjee's wife is extremely ill. She is
This is part-head matter. No adjournment can be granted.
It's a very critical ground. Her blood has to be.
No adjournment, sir. In that situation, you should have to prepare yourself.
He was there in the morning from the Bezur doctor called that it's very urgent. You have to come for transferring the blood. That's why he left from the court.
So written notes of argument has already been submitted by you. What more you want to add? Already written notes of arguments are in.
Only one.
Not required. Who is for the OP? Yes. Where is the status report? What is the status of trial? No direction to file a status. No direction is here given to file a order dated. Order dated. No.
Total will be on top.
Forget about the compliance of that. You place your submission. Already 8 years, 7 years has been. No, the written notes of argument is here. So verbal submission is not required. Whatever he has to say is here. All cases are referred here. Not required. Leave it. Leave it. Let me conclude this matter here. And no, sir. No. No.
Was there from the morning. That's why I have to live. Lordship just for a day.
Very well. You are not required to present here. I will proceed on the basis of the material available.
One Mr. Nikhil wants me to get the code also. That's why
No, last 7 years you are under the medical emergency.
for David. Because the last one.
I am talking about. And you call the Mr. Raj Chaudhary, Ranveer Raj Chaudhary in the meeting. Yes. Pass it over.
I have no picture on the matter.
No, no, but I have no adjournment. Parted matter, no adjournment.
Item number 3.
Hmm.
Lord,
Hmm.
for the state, I'm praying for adjournment.
Why? Why state is praying for an adjournment?
My Lord, Mr. Ronodeep Sengupta,
Petitioner is not here. No adjournment can be granted.
today,
No. 9 years has been passed.
actually, Mr. Ronodeep Sengupta was stuck in 35, then passed.
No. Either you yeah, make your submission, otherwise I will pass out.
Then give me Passover, my Lord.
No adjournment can be granted. At best, I can give 10 minutes Passover, go through with the content, and
One point, Your Lordship, on the last page, Your Lordship mentioned that the copy of the revision application submitted by us to give copy to them, but we don't have the copy of that.
when that direction was given,
31st of the last page.
none appears on behalf of the petitioner. You were not present on that day. Then
You know, direct this to give a copy to them of the revision application. You know, so that then we get a copy, we'll give it to them the very next day.
who is for the CID?
One more thing, Your Lordship, that on 8th of August, they have the CIS filed the report, but they didn't get a copy of the report.
What is in this matter? What in this matter? Nothing in this matter. Take down. This criminal revision has been filed under section 401, read with section 482 of the CRPC by Shankar Bose, the uncle of missing child Abhijit Bose. Full stop. The petitioners seeks to petitioner seeks to quash the order dated March 16, 2016, passed by learned 10th Judge, 10th Judicial Magistrate, Alipur, 24 Pragnas South, on the ground that the magistrate failed to consider a pending Naraji petition before framing a charge under Section 363 of the Indian Penal Code against the accused Saraswati Misra. Accused OP number 2. OP number 2, accused Saraswati Misra. The fact of this case are deeply distressing. A 7-year-old boy, Avijit Bose, went missing on February 21, 2008. Full stop. The child's father, an employee of the railway, had left him in the care of the accused. When he returned, the child was gone. An FIR was lodged on February 25, 2008. The subsequent investigation by the Westport Police Station culminated in a charge sheet being filed against the accused on July 15, 2010, despite the child July 15, 2010, despite the child never being recovered. Being aggrieved by what they consider a perfunctory and incomplete investigation, the petitioner and the victim's father filed a Naraji petition on April 21. Yes, you are for the CID. Yeah. Naraji petition on April 21st, 2011, requesting a more thorough probe, a more thorough investigation. This petition remained pending for over 4 years. On March 16, 2016, the learned magistrate, without addressing the pending Naraji petition, proceeded to frame charge against the accused. This action, the petitioner contains, is a travesty of justice and travesty of justice and legally unsound. The central question, paragraph, before this court is whether a trial court can legally frame charge without considering the pending Naraji petition. That challenges the very foundation of the police investigation. The paragraph. The Naraji petition, in essence, is a formal protest by a complainant against the police report with which they are dissatisfied. The Supreme Court has repeatedly affirmed that a magistrate is not a mere post office. It is well settled principle that when a magistrate receives a police report, they have a judicial duty to apply their mind to all materials, including any protests from the complainant. By keeping the Naraji petition pending and proceeding to frame charges, the learned magistrate bypassed a crucial judicial stop. This action demonstrates a failure to exercise sound judicial discretion and constitute a grave procedural irregularity. The paragraph. In any event, a trial court cannot legally frame a charge. Trial court cannot legally frame a charge against an accused person without first considering and disposing of a pending Naraji petition. Full stop. Ignoring such a petition is tantamount to denying the complainant their fundamental right to be heard. Paragraph. The decision to frame a charge implies the court is satisfied there are sufficient ground to proceed. However, if a petition alleges the investigation was flawed, alleges the investigation was flawed and incomplete, it is the court's duty to consider those allegations before coming to a definitive conclusion. The failure to do so renders the order legally untenable. The facts of this case, particularly the prolonged failure to recover the child, underscore the need for a competent investigation. The petitioner's concerns were independently validated
Not only one
by this
interruption.
court's own direction to transfer the case to the CID for further investigation as noted in the status report. This change of agency speaks volumes about the deficiency in the initial probe. Paragraph. For the foregoing reasons, the impugned order dated March 16, 2016 is flawed and cannot be sustained. March 16, 2016 is flawed and cannot be sustained. The act of framing a charge on flawed foundation is a serious error. In view of the foregoing discussions, this court finds sufficient merit in this case. Accordingly, the CRR 2360 of 2016.
One submission may I make. In this case, this honorable court was pleased to direct, considering at the interim stage, directing CID to take up the investigation.
Yes.
Police was there. Police initially filed a charge sheet. Now, from there, they preferred that Naraji petition. Before this honorable court, we were entrusted with, we have filed our final report. That
Yes, I have mentioned it.
Hello?
I have mentioned it that you have filed your final report. It has already been mentioned. It succeeded. Consequently, 2360 or 2016 is succeeded. Consequently, the impugned order dated March 16, 2016, passed by the learned 10th Judicial Magistrate Alipur, 24 Pragnas South, is hereby quashed and set aside. The case is remitted back to the court of the learned 10th Judicial Magistrate Alipur. The learned magistrate is directed to first take up and hear the Naraji petition filed on April 21, 2011 and pass a reasoned order on its merit in accordance with the law. The learned magistrate shall afford a full hearing to the petitioner on the merit of his protest before passing a fresh order.
But Lordship is pleased to my lord set aside the order under challenge,
Yes.
and then my lord further investigation. But my lord further investigation by the CID pursuant to this honorable court's order,
No further investigation.
my lord,
Remitted back to the
for
trial
the
court,
purpose of hearing of that Naraji petition.
Naraji
Now,
petition.
my lord, if your lordship kindly consider
And
this,
everything is upon the judicial magistrate who
Sir.
will take decision that whether further investigation is necessary or not.
lordship kindly consider this. My lord, that was under challenge before this honorable court. This honorable court, considering my lord, the authenticity of the order, my lord, or my lord,
Authenticity of
my lord,
impugned
the
order.
report, my lord, that was filed, and my lord,
No,
the
no.
Naraji petition, my lord, already
Authenticity of
proven
report is not a matter of challenge here.
my lord, Naraji petition was not heard,
Yeah.
was not taken into consideration. That was their grievance.
Impugned order is the order of learned trial court
Yes. For
by
negative,
which
negative,
he proceeded to frame charge
yes,
without disposing the Naraji petition.
my lord.
This is the main contention.
Now, my lord, considering that, my lord, that the investigation was not proper, now, my lord, we were interested. My lord, in 2016. Now, my lord, till this extent, to the extent possible, because we are a superior.
For that, learned trial judge will pass necessary direction.
You
Investigation.
already have done. My lord,
Yes, you have done, and
my lord,
upon
your lordship has
on the
considered.
basis of your report,
Yes.
I proceeded to pass this order.
Your lordship has already considered our report. My lord, the same thing again will be considered by the magistrate.
Your report is considered only for the purpose that whether this matter could be disposed of or not. Now I am taking this matter for.
My lord, my report will be considered by the magistrate himself.
No, your report is only in respect of the investigation.
Yes. Further investigation that we have carried out.
As to the whereabout of the missing child.
My lord.
And you submit your report that you failed to get any trace
Yes.
of missing child. That's all.
And my lord, we have said that whatever the
Your
charge sheet
report
that was
would
filed,
be your report and charge sheet would be accepted by the trial court. High court
my lord, if
at
your
the
lordship has
at the
considered-
revisional determination
My lord.
has no any authority to accept your report or charge sheet. However, I will give direction to learned trial judge. কি লিখলেন? কি লিখলেন? The on last কি আছে? Learned magistrate shall afford a full hearing. Passing a fresh order. This is for you. The ongoing investigation by the CID, Criminal Investigation Department.
It has reached its conclusion.
Yes.
Lord, we have said, my lord, that
West
we have not
Bengal,
found. Lord, whatever
as
the charge
directed
sheet
by
that was
the
filed by the
court's
police is
previous
due.
order.
No investigation is pending. We have reached final report filed. Last paragraph, my lord, the last page. That
Has already concluded.
Yes.
And charge sheet has been filed.
charge sheet that was filed by the police, we said that the trial may be proceeded on that. We haven't found anything new.
You have concluded your. Where is your charge sheet? You have to file your charge sheet before the CGF.
Final report has already been filed.
Where?
That record.
Where?
In that record before the learned CJ.
The learned CGM will
Consider
take
that.
this. Yes.
That final report.
Yeah.
Okay, go.
Did you file any report in this regard that
26th August report, my lord, can you see, lord, before your lordship that we have filed 6th August 25. Last date, date before the last. We have filed multiple reports. The last one was 6th.
What is the content of 24?
I have a copy very handy. The same report has been filed. The last paragraph of the last page.
Last report. It appears from the report submitted by CID on 6th August 2025 that
The last two paragraphs. Just before that, above that, the paragraph you are
no pressure. Hence, I have submitted a final report. That final report has been submitted by CID on 4th August 2025 before learned Judicial Magistrate First Class 10th Court Alipur. The trial court shall take necessary steps in the matter on the basis of the charge sheet filed by the CID. This court trusts that a competent and thorough investigation this application is accordingly disposed of. Any CRAN? No CRAN. Interim order, if any, stands vacated. There is no order as to the cost.
Lord, my lord has been pleased to direct Lord trial court to proceed on the basis of the report filed by us.
Yes, trial court will proceed. Yes,
Right.
disposal.
May I take back copy of that report?
Yes, yes, why not? This is your copy.
Number 4. I have taken instruction. Of CBI. Now, at present, told me that the copy of the initial application is not with the
Who-
CBI.
Who is for the Kunal Kumar Ghosh?
Now, may I
Why further instruction? 9 years has already been passed. No.
My lord, may I submit one thing? My lord, what instructions I get from the IO?
Will not grant any further.
My lord, subject to correction from your lordship, my lord, the revisional application, though the copy is not with the CBI right now, is perhaps become infructuous because this revisional application has been filed by the petitioner in the year 2016
Yes.
for clubbing of CBI RC case number 6 of 2014, 4 of 2014. Now you lordship kindly produce the record. I don't have the copy. Final charge sheet
has already been filed in RC6 of 14. Petition has become infra. That is the
So
instruction.
you file,
I may file a report, my lord.
yeah, file a report.
I will file a report. Your lordship kindly gives me 2 weeks time, my lord. আর ওইটা বলছি তো।
One week time is sufficient.
মানে 10 days, my lord. 10 days. Because there is a procedure of vetting. Your lordship has vast experience knows, my lord.
Take down.
বলছি, and a copy of the revisional application, my lord, may be served upon my lord and the petitioner because I'm handicapped. শোন না, তুই সিবিআর তো মামলা করছিস।
Learned advocate for the CBI prays for time to submit report. In respect of the status of pending RC 6/S/2020 2014 and RC 4
Yes.
and RC 4/S
S of 14.
of 14. Let this matter adjourn till 21. Learned advocate for the petitioner is directed to serve a copy of this revisional application here and now.
Bibliography.
अपने दिए थे 25 now.
Item number 5.
5, I am for the petition.
Who is for the
Peculiar matter. I say
who
so
is for
because
the RKD not represented?
they are not represented and their presence is very much required. I will tell your lordship why. And at first, your lordship will
Did you take a
seven-
step?
Yes, my lord, all the steps were done. Your lordship has directed me. I have served on the name. Your lordship even probably has recorded that on the last occasion.
He is never represented.
My lord, I will tell your lordship why not represented. My lord, if your lordship allow me for 2 minutes.
Yes.
My lord, kindly takes page 17 of my application. From page 18 actually. My lord, this relates to, my lord, TDS deduction. My lord, when an employee works in a company, a TDS is deducted by the employer and which the employer is supposed to deposit to the tax authorities. So, my lord, for the relevant year, my lord, few taxes, my lord, were not paid. Your lordship has got, my lord, which amounts to, my lord, 200 and 250 rupees. And we'll get that in paragraph 4 and 5, appearing in page 90. Lordship has got that.
What is your status? 2, 3 above name material directors of the accused company. You are
Well, I am the
your
company.
company.
I am the employer.
No, director. You are director.
Yes, man. I am for the Josna Investment Company Limited.
Okay.
The company has been made an accused.
Yes.
The lordship had got that?
What is the tax liability?
No, my lord. The tax liability is now been extinguished. Why, your lordship? I will tell your lordship. Now, what happened is that out of this this transaction, this tax default, numerous FIR, numerous complaints were registered by the income tax authority. And my lord, for different amounts. So, my lord, we filed a composite application before the commissioner for compounding of those amount and assessments of the same. My lord, thereafter, what happened is that My lord, the commissioner, while the commission was pending adjudication, this compounding procedure, my lord, we prefer an appeal before this honorable court.
Hmm.
My lord, will kindly take, my lord, page, my lord, 20, my lord, 21.
Hmm.
Is all these applications were taken up by this honorable court. And this honorable court directed that the income tax authorities is from taking any step in a criminal
No,
proceeding.
whether this revision is maintainable.
My lord?
This revision is maintainable
Yes, my lord.
against the
My lord, this has been paid.
The
The entire
order.
thing has been compounded.
against the order in C1271. What is C1271?
Is the complaint case.
Oh, complaint case.
My lord, will kindly see this.
Where is the implementer? Page
My lord,
number.
before that, your lordship will kindly see the observation in page 21.
Yes. Hmm.
The respondents are not to proceed further in the pending criminal proceeding till application for counterclaim of involved in the appellant has been disposed of by the commissioner. This order was passed by this honorable court for effecting the compromise between the parties. That compromise has taken place.
Hmm.
We have paid the entire sum, which has been calculated. But thereafter, they stopped appearing.
Where is those documents?
Yes, my lord. My lord will see first, my lord, page 23. Thereafter, 24, 25 is the assessment, and the challan is at page 27. And thereafter, my lord, communication of payment at page 28.
23 appeal number. Attendance is necessary. 23 is the
present-
notice. At page number 23, this is a notice under section
Right.
250.
Right.
Page number 24.
The assessment. The typed version is at page 25 because it's illegible. Page 25 is the typed version.
With reference to the challan sum of
Then page 27 is the payment. The amount. This in respect of all the offences compounded by the commissioner.
36,086 rupees.
3,96,943 rupees.
This is the sum.
Yes.
I am enclosing here with a challan for a sum of 396,943, being composition fee amounting to 12,50,857 and establishment tax. Please make the payment immediately and produce the receiving. Yes. To the principal officer. Then what you did?
No, my lord. Pursuant to your lordship direction, we have served upon the concerned office as well as the complainant. My lord, it could not be, my lord, they did not appear. My lord, in this matter, my lord, the presence of the income tax is very much required for ascertain this part. My lord, what I am asking your lordship kindly directs me to serve on Union of India. I can make the Union of India party. My lord, that will serve the purpose. I can effect service on additional solicitor general, my lord.
Did you serve notice upon Union
Yes,
of
yes,
India?
yes, I have. My lord, your lordship kindly see the order sheets. Your lordship has on last occasion recorded that. Your lordship, initially we have effected service upon the complainant.
No,
Then your
only
lordship has asked me to effect service upon the office. We have done that.
Josna Investment is the
Is my
petitioner.
company. I
Is
am
the
replacing-
petitioner. And RK, the income tax officer.
Yes. So RK probably has superannuated it from his office.
Maybe.
Yes. Thereafter, we have served upon the officer.
You did not implead Union of India in your.
Because that was not recorded because at that time.
No.
complainant, my lord, the difficulty is that if the complainant doesn't appear after the matter being compounded,
You submit your document, whatever document you have in your favor.
yes,
That
my lord, once the application is compounded, it cannot be proceeded. My lord, you can
where are those documents? File them and
my lord, so far as my lord, because your lordship, I have relied upon an order of this honorable court precluding them authority from proceeding in a criminal proceeding. That is page 21. Only document which I have not annexed probably is the memo of appeal. That I can bring on record, if your lordship want.
memo of appeal of
My lord, this, my lord, your lordship,
appeal
is page 20,
page 21 P3.
page 21 and 22,
Hmm.
the order where this honorable court directs the no proceeding will be continued.
Whether this order was passed in connection with this case.
Yes, that if I bring the memo of appeal, it will
Did
be.
did you show this order to the authority concerned?
Yes, well, thereafter compounded. We have paid the entire amount.
Where is the order of compounding?
Well, this commissioner assessing thereafter, your lordship sees the assessment amount page 26 and entire payment being made.
Page number?
My lord, page 26 is the authority informing us. My lord, here is the amount.
It appears from your letter.
Page 25, principal
the
officer
principal.
being communicated the quantum of the amount
Yes.
and that amount being paid.
In this connection, you are advised to see the undersigned in my office at any working day. Then what happened?
All the process dropped. This they did not do anything because in view of.
Did you pay this amount?
Yes.
Where is that?
My lord, that challan here, lordship, kindly see page 27.
Yes. Then
This,
any order?
no, thereafter we
After payment?
communicated that. Thereafter those proceedings were not continued. And this criminal proceeding they did not pursue. And we are stuck there in the criminal proceeding.
Where is the impugned order? Show me impugned order.
And it will kindly, it will be certified copy.
Why impugned order are not with the record?
It should be with the record. My lord, it's a change brief. I don't know whether
Refer the page number, no?
it should be there, my lord. At the end of the petition, there will be.
Complaint. Okay, they. Further proceeding, see 1, 2. Yes. 3127. Your prayer is to stay all further proceeding. It is all order
All orders be set aside.
27th April 2016. This is the order 27th April 2016. Today is for the submission of documents. No audit of petitioner of accused persons detained or discharge of accused
My lord, I have prayed for quashing of the entirety at page 13.
Okay, come prepare after going through with all orders. Come prepare only.
Well-
None appears on behalf of the petition, opposite party. Despite several
I can give me
Direction.
to epic service if your lordship so wishes.
this is a very good case. Let this matter adjourned for a week with a direction to learned advocate for the petitioner to come prepare on the adjourned date.
Can he direct me to effect service if your lordship wants?
To whom? To whom?
To the authority again, how, whom, because normally, my lord, they are not appearing.
No, I had directed you earlier to
I have done.
serve upon the income tax. Then after proper service, further direction is not required.
Because, my lord, those sections under which this proceeding has been initiated, subject to correction, my lord, I will produce that, now has been decriminalized. My lord, this proceeding, my lord, will
They come prepare. Let this matter fix under the heading of hearing. Yes, come on next date with proper preparation. We'll hear and dispose of. Yes.
Item number six.
Yes, yes. Item number 6.
Direction by your lordship to produce the bed.
You are for the estate.
Petitioner.
Yes.
There was a direction by your lordship to produce the death certificate, my lord.
Death
The last
certificate of
occasion happened.
Kedarnath's expert. Yes. Then he is the sole appellant. Revisionist.
My lord, there are two petitioners. So my lord will kindly grant me
So
leave
his
to
name.
not press the application. My lord will see your lordship's last order.
Yeah.
31st-10-2025, my lord.
Yes.
So my lord, this is the death certificate.
Oh, he died in the year of 2017.
My lord. No, it was filed in 2017.
After filing of this
My lord.
regional
My
application.
lord.
And what about the Pawan Kumar Dut?
My lord, I have instructions to withdraw this application, not press it.
Where is
Kindly dismiss the application.
where is your application?
Information, definitive statement
Oh,
was made
okay.
against the petition number 1. Now he has expired, death certificate already been given.
Yes.
So no point pursuing this matter anymore.
Hmm.
The lordship cannot press this. We are not pressing this application.
Where is the application for withdrawal?
Withdraw.
Withdrawal, we got instruction to withdraw it.
File a written instruction in writing. Na?
Yes, verbally.
Not press it, we can always do that,
Verbally.
because from the very beginning we were the advocate present here.
Record.
No, today everything is okay. After few years, no one would be available, and he
And
may
it's a case of defamation. It's not a case of
whatever it may be, but your written instruction would be the part of this record, and that will be available forever. So for
That
the
is true. What your lordship is
for the
saying.
best interest of you and everyone.
And in this case, we are not the accused, we are the complainant.
Yeah.
We are the
So
complainant.
just file a
We'll
two
file.
lines application and we'll pass out a recording.
Very well.
Learned advocate for the petitioner file a death certificate of petitioner number 1 Kedarnath Dut. The certificate is taken on record. He further submits that he has instruction to not press this application for filing a written instruction. He seeks a week's accommodation.
Just 4 weeks.
Weeks to, my lord.
4 weeks time, because
File
it's
the
not in
application.
Calcutta. So it's an old matter. We need to contact them and bring it.
When you may collect email instruction on email copy.
As your lordship.
1 week is sufficient.
Weeks. Give it 2 weeks.
Yeah. A 2 weeks adjournment. Let this matter appear on 21st November.
21st November.
21st.
Item number 7. Seven, I am appealing to proceed further.
আইটেম নাম্বার 7
Yes.
আমার উকিল সাহেব আমার কাছে পয়সা নিয়েছে, কন্টাক্ট করেছে, আমাকে বলছে যাও যাচ্ছি, আসেনি। বাদী আসামি পক্ষের সাথে কি কন্টাক্ট করেছে, প্রতারণা করেছে জানি না, আমার প্রত্যেক খালি ডেট দিচ্ছে, কোনো ডেটে হিয়ারিং করছে না। আমাকে স্যার একটা ডেট দিবা হোক, নেক্সট একটা অন্য উকিল দিয়ে
Okay.
আমি বলছি একটা নেক্সট ডেট দিবা হোক, আমি অন্য উকিল দিয়ে এসে হিয়ারিং করাবো কেসটা।
A petitioner appears in person
আর ওই
and
উকিল যে
pays
আমার
for time
প্রতারণা করেছে, ওই ফিরে স্যার যেটা ব্যবস্থা নেবে সেটা আপনি নিন।
to take a step on the adjourned date by engaging a fresh advocate let this matter adjourn for a week.
Kindly keep it on 20.
14 तारीख আসবে
Kindly keep it on 21st minute.
ভাই
21st minute.
ভাই
14th, your lordship has fixed the matter. Kindly keep it on 21st.
21st
21 তারিখে আসবে।
21 তারিখ
for the 2 weeks 2 week कर दो right 21st
একটা কাগজে লিখে দিন next।
yes
Item number 8.
Petition I with written notes of argument. It's ready in your lordship and it's
heard the party on the prayer of let this matter adjourn for a week to file written notice of. Where is your written notice of?
it's ready, just I need to
Your submission yes
business transaction is still persisting and I have submitted the written notes of arguments. I'll just hand it over, lordship. Kindly grant me 5 minutes.
would you also want to file written notice of argument?
No, no.
Not really.
Already after submission, can we consider the civil list? There are civil checks, the 7 account pay check. In the name of the department complaint in the year 2015, whereas in the year 2014, the company, the petitioner is the director of both the petitioner and the director of the company.
Did you file your CD? Case diary is there? Yes. Ache.
If this transaction is still persisting, I'll hand over.
Yes, file your written notice of argument for CAB.
Annexure P1, the return, then the order, I put order. So that order, the company has already paid up on the year 2014. But thereafter, very fully well,
Annexure?
it's a P1, page 16 of the divisional activities. Last year,
Lordship, thereafter the company revived. Now the business transaction is still persisting.
after issuing the check. In the year 2014, the company has already been filled up. 2015, I issued several checks. All the checks were dissolved. But she has intention to keep the amount. We have fully know he has no amount.
Okay.
Consider the season list.
Against the order of conviction?
No.
Then?
Case of complaint.
So why check bounce?
Well,
Issue of check bounce 138 is there or not?
No, Lordship.
that is not another thing. The intention, the conduct of the petitioner, both the directions of the company.
Okay. Written notes of argument and here the net advocate for the petitioner hands over the written notes of argument. Let it be kept with record. Argument concluded. CAV. Yes.
Any.
Is there any reason?
Case diary ache dekhen. Verify whether case diary is there or not.
না দিচ্ছি আমি আগের দিনকে দিয়েছি
Item number 9.
থাকলে লিখে যাবে case diary.
Pilot, I'm praying for
Yes. Intercoordinate.
Pilot, on behalf of Mr. Arnav Chatterjee, I'm praying for short passover as he is engaged in court number 35.
Who?
Mr. Arnav Chatterjee.
Short passover. 10 minutes passover.
Item number 2 का भी पास हो गया।
हाँ रखिए 3:10 3:15 होगा तब बुलाएंगे।
So item number 10, my learned friend was appearing on the last occasion and she sought time. Well, I have argued this matter because your lordship case diary is required. My lord, this is that matter, my lord, where a person purchases a truck, he cannot repay the loan amount. When he could not repay the loan amount, the bank proceeds against that person. The person comes up with a Cox and Bull story that he had purchased the truck at the instruction of the present petitioner, who is used to be his employer. All the documents signed by him, all the loan availed by him, truck is in his possession.
Why CD is required?
Because your lordship wanted to see the documents, what basis this
Or?
case can continue.
OP to purchase a truck.
My lord, a person purchases a truck.
Default in.
He avails a loan facility. He could not repay the loan.
Yes.
Every document, everywhere, everything in his name.
Yes.
Thereafter, when the bank proceeds against this person who could not repay the loan after.
Are OP disputing these facts?
OP is saying that I have done it at the instruction of my owner, my employer,
Oh,
and they are.
as per you, OP himself was the owner of this truck and no employer was there.
No, OP is the owner of the truck. It is admitted fact. OP signed document. It is also admitted fact.
Then
He has instituted a criminal case against the present petitioner.
who is his employer? Who is his employer?
Present petitioner.
Petitioner is the employer.
As per him, I was once an employer of him. I has asked him to purchase the truck. So he had purchased the truck. He has availed the loan. But because I have asked him to purchase the truck, it is actually I am the owner of the truck and he has no liability. For that, he instituted a criminal case against me. And invokes provisions like forgery, my lord, where all documents are signed by him. Your lordship was.
No direction is given to call for.
Last occasion, she said that she will take time. My lord, kindly cease.
Lordship, Miss Faria Hussain is appearing in this matter.
No, then you come prepared. Faria Hussain is not here.
It's like this, Lordship. Cannot. She is allotted this matter. How can
It
it
took
appear?
time on the last occasion.
It's not there.
Yeah.
That's why I appeared.
So only for the want of
I'll inform her.
appearance of Faria Hussain, it cannot be.
Kindly takes it up next week. I'll inform her.
Then what you did in between? This order was passed on 24th October.
Faria Hussain was out of town. That is why I took time. Kindly passes it over. I'll inform her.
Learned advocate for the estate submits that Faria Hussain,
আজকে আমাকে দাঁড় করালেন।
Because you took time.
Miss Faria Hussain, who represent the estate in this case, is not in the town.
Lordship, on the last occasion, she was not in town.
What happened today? Is she in court?
Your Lordship.
Call her.
That's what I'm saying.
Pass it over once. Yes.
Very old matter.
Other matter were also very old. None appears on behalf of the who is for the party. Yes. Let this matter urgent. Necessary order will be passed. Again, necessary order pass. None appears on behalf of the parties, nor any accommodation is prayed for, despite several directions. None appears on behalf of the petitioner party. Petitioner last represented on 13th November 2017. Thereafter, he avoided to take any step. No, बोल अच्छा ই করবে 21/3/2025 পর্যন্ত আছে। Thereafter he will have to take any step since last several dates. As this matter is very old, state is represented by owner. As this matter is very old and already parties were directed to take necessary step by today, petitioner prefer not to appear, not to take any step. Accordingly, this matter is taken up for passing order. This is an application under section 482 of the CRPC referred by Mustabari Dhabar, for setting aside and or quashing of the order, judgment and order dated 12th September 2017 passed by Learned Additional District and Session Judge, Fast Track Court number 1, Bongaon, North 24 Parganas in Criminal Appeal number 2 of 15, bracket 3/13, thereby affirming the judgment dated 9th September 2013 passed by Learned JM Bongaon in TR case number 249 of 2001, GR case number 875 of 2000 in connection with Bagda Police Station case number 245 of 2000 dated 11th September 2000 under section 341-325 of the IPC, thereby affirming the order and judgment of conviction under section 341 of the IPC, sentencing the petitioner to simple imprisonment of 15 days and fine of 250 rupees, in default simple imprisonment of 5 days, and the conviction under section 323 of the IPC to simple imprisonment of 5 months and fine of 500 rupees, in default simple imprisonment of 1 month. It appears from the impugned judgment that Shahjahan Mandal lodged a written complaint at Bagda police station on 11th September 2000 with a complaint with a series of allegations that on 10th September 2000 at about 6:30 a.m. when Kudus Ali was going to Dhantala market for selling night queen flower and reached at Newlipara village, the accused Mostabari Dhabak asking him to Dhabak assaulted him with lathi wherein he sustained injury at his both hand and bleeding injury at left forehead. Hearing his hue and cry, local people rushed to the place of occurrence. Kudus Ali became senseless, and he was taken to Baghdad hospital for treatment. This written complaint was the genesis of Baghdad PS case number 245 of 245 dated 11th 9 2000. I find that learned judge has considered the evidence of witnesses recorded during the trial and after proper evaluation, he arrived at the finding to hold the petitioner guilty. Accordingly, he passed the impugned judgment. Prima facie, I do not find in appellate the learned appellate judge reassessed the evidence and finding of the learned trial court and affirmed his finding by stating appropriate reason. I do not find any irregularity, illegality, or impropriety in the findings which may invite the intervention of this court at this stage. Accordingly, this application is dismissed. बाकी कंसिक्वेंशियल ऑर्डर दिया था. Yes. Yes, dismissed. हाँ बुला लीजिए.
Item number 2, passover matter.
Yes. If any one of you may want to continue, then I. Okay.
Item number 2.
Well, before you,
Before my lord takes up item number 2.
Where are you, lady?
it was there, my lord. She
Item number 2. You are Faria Hussain.
Yes, my lord. My lord, with regard to item number 10, I was called. My lord, the brief and the case diary is with my junior. He
Just wait.
has met with an accident.
At present, I am on item number 2. Yes. Written notes of argument has been filed. So, what is this report, sir?
Because it was after a long time, they could not cross the survey. State was directed, but state has served, everybody has received. It was sent through speed post, last 2 pages, the track remote has revealed that.
It was submitted. Charge sheet has been submitted.
Charge sheet was submitted in 2019.
19. Landed SMU Calcutta. The case is still in SR stage. Has not been served.
At that stage, they have come for washing of the entire proceeding. Your Lordship, I asked Mr. Mukherjee, he frequently but as it was part of your Lordship directed.
Yes, the written notes of argument on behalf of the petitioner has been filed. Yes. So, if you want, you can.
Yes.
If you think that case that diary is necessary, then you can. And do you have anything to submit? Your submission?
Your submission charge sheet has been filed in 2009.
Filed.
Prima facie at this stage, but case is made out so far. This allegations which has been substantiated.
Okay.
That's
My lord, Mr. Moyuk Mukherjee is appearing in this matter, my lord. He is not present due to some personal difficulty. I'm praying for.
Then his name could not be. Yeah. You give your representation. To the.
My lord, for 5 minutes, my lord.
Just for case diary we kept with the record. Yes. You give your representation only, madam. Yes. Thank you. Thank you. Yes.
Lordship, heard this. Lordship, can you produce your Lordship's last order?
On behalf of the prisoner place for an accommodation on the ground of such demand of the ground. It is thus. You are for the petitioner.
I am for the petitioner.
Who is for the state and Union of Union of
Mr.
India?
Kollol Basu and Mr. Priyankar Ganguly is there for Narcotic Control Bureau.
Oh, NDPS matter.
NDPS matter.
None appears to represent OP OPs. Learned advocate for the OPs are directed to take necessary steps on the adjourned date. Let this matter adjourn for a week.
Actually, fixing.
A week after a week, 14.
Item number 10.
But there's a difficulty in this matter today because my junior is having the brief and the case diary has met with an accident.
Madam, it is a very old case. And if you all,
Today's accommodation, Malad, I'll do it on Monday. Malad, I'll take
I-
the case diary from.
I could grant an accommodation today, but on the condition that you will come prepare on next day.
Yes,
And no excuse will be entertained on that day.
no, Malad, on Monday I will do that.
Okay. On the prayer of learned advocate for the state, let this matter adjourn for a week. Next Friday, come. Yes, call the list.
Item number 12.
12 and 13. My lord, it arises out of
Yes,
same case. My lord, this matter I need 2 weeks because I will file a compromise application. My lord, will kindly see this order. My lord, this affidavit.
yes.
My lord, it's a
Ground of
commercial dispute initially given a cloak of criminal offense. A complaint case was initiated where there is admittedly part payment. My lord, now the dispute has been settled by and between the parties. The opposite party has filed the application before the concerned magistrate. My lord, we will file a compromise application.
12 and 13 both will have.
Where is the written notes of argument? It was written for
There is no written notes of argument because this is if I file
learned advocate for the petitioner. Who is for the OP?
Is there some
OP is not
initially he was appearing, not appearing, but they will appear, my lord. They have filed a
for the
hearing.
petitioner. Praise for a week's adjournment,
2 weeks adjournment.
2 weeks adjournment for filing
A joint compromise application.
a joint compromise petition as the talk of settlement is in progress. Let this matter adjourn till 21st. Yes,
13.
And the same matter.
13 हो गया 12 तेरे 1 से 14
Your Lordship,
देखिए
I am
मेरा
appealing for the petitioner. My Lord, this matter pertains to, on behalf of CBI, challenging, it is a very interesting matter, my Lord, challenging the order of sanction, my Lord, which was, my Lord, granted by CBI against the public servant. Now, my Lord, that was challenged and that was turned down against us by the learned trial court. The point was that.
that order has been challenged.
Yes, I'm grateful. Already,
No, yeah. Start your submission.
yes, I can start, but it will take time.
My student, Mr. Honorable Chair, taking not today.
Why? Why not today? You are for the
Division to the
Opposite party. Let me my student, Mr. Honorable Chair.
matter was heard, my lord, for days together before the Honorable Justice Shampa Dattopal. Thereafter, after change of determination, it comes before your lordship.
yes.
Well, a short point involved already written notes of argument and supplementary written notes of argument.
Written note of argument has been filed.
Yes, it's filed
Supplementary
long back.
note of convenience on behalf of the. Then what remains to submit more?
Your lordship.
Everything is on record.
My lord, the difficulty is that because your lordship is hearing this matter for the first time, so your lordship may kindly fix a date, my lord, so that I can complete.
Next week, next week.
Next week, my lord, after 17th, any date, my lord. Because I may be out of station, that is any date.
That would cause unnecessary delay.
No, I am ready with the matter.
Very well, on the prayer of learned advocate for the petitioner.
On the opposite party, my lord. I don't pray for time. I am ready with the matter today also.
Learned advocate. Then you start, no?
Yes, I am starting.
You
Your
start.
lordship kindly comes to the impugn order.
Yes.
5th of April 19. May I place the impugn order?
You take note of his argument.
May I place, my lord?
Impugn order is on?
On, my lord, the last page, my lord. 5th of April 19. Order number 57. Your lordship got in the revisional application. My revisional application. Your lordship got, my lord?
Yes. Where is the?
Your lordship is taking the revisional application, my lord.
Yes, yes.
Here,
Yes.
the last, your lordship,
Last,
please see
yes.
impugn order. 5th of April 19, order number 57.
5th of April 19.
Yes, may I please? An application is filed on behalf of accused Chandranath Koyal under section 239 CRPC in course of evidence praying for discharge on the ground of validity of sanction on the competency of the sanctioning authority. The accused is facing trial under section 7 and 13(2) and 13(1)(d) of the PC Act 1988 for demanding an illegal gratification of rupees 2,000 from one Sri Utpal Ghosh for facilitating income tax refund of rupees 55,342. And a written complaint was lodged to that effect on 1st of May 2012. At the relevant time, the accused person was income tax officer posted in ward number 54-2, Income Tax Office, 3rd Government Place, Kolkata. PW1 Aniruddha Mukherjee is examined as the sanctioning authority and the sanction order is marked as Exhibit 1. And PW2, PW3 and PW4 have been examined in part. Commission of Income Director. Now, your lordship, here I am pausing here for a moment. When the, my lord, this penal action was taken against the petitioner, admittedly, he was working as ITO under the Commissioner of Income Tax. Your lordship kindly makes the point, my lord. Commissioner of Income Tax, when the offence was commenced. At this stage, a plea has been taken by the defense that the sanctioning authority at the relevant of time, Commissioner of Income Tax, in that capacity, he accorded sanction for prosecution against the accused person on 11 July 12. Though the accused person was appointed as income tax officer on promotion by G. Chaudhuri, supplementary Chief Commissioner of Income Tax, the Kolkata such and such. Now, the boiling issue here is that, my lord, with greatest respect, your lordship has vast experience. There is a difference of service jurisprudence in respect of Prevention of Corruption Act. What is the service jurisprudence? The appointing authority and the removal authority will be the same person. But in the Prevention of Corruption Act, Prevention of Corruption, if your lordship kindly takes, my lord, 19, may I place 2, my lord, if you just have kindly see. Here, my lord, at the time of comments, the person and the removal authority. Kindly see, your lordship.
Government of given by that.
Your lordship got my lord.
To remove the public servant.
Yes.
Now,
this is the only point. Evidence was started. Your lordship knows so far sanctioned. There are several judgments of the Honorable Supreme Court that I have annexed. Mere error or omission will not absolve the sanction order. But here is that whether the Commissioner of Income Tax is empowered to accord sanction against prosecution in respect of this complaint. Now, if your lordship kindly once takes my supplementary affidavit, supplementary written notes, there I have annexed, my lord, the particular order by which the Commissioner of Income Tax
supplementary note of
yes, notes of argument, my lord. Your lordship
convenience on behalf of respondent.
Page 10. The gazette has been annexed and it has been referred before the learned trial court. In spite of that, it was not considered. Your lordship got the page 10.
Yes. Yes.
Yes. Now,
Gazette of India.
I'm grateful. Now, Your Lordship, kindly see the second table. First column, Your Lordship, leave left-hand side second. Income tax officers, Group B, whose when posted in offices, Your Lordship got, my lord, when posted in offices other than those of Chief Commissioner of Income Tax, stroke Director General of Income Tax. Admittedly, when the offence was, my lord, committed, I was posted under the Commissioner of Income Tax, not under the Chief Commissioner of Income Tax or Directorate of Income Tax. Now kindly see the second one, appointing authority. My appointing authority is Commissioner of Income Tax, stroke Directorate of Income Tax. Now, kindly see authority competent to impose penalties, that is on the top, and penalties which it may impose. With reference to item number 2, we are on item number 2. That is Commissioner of Income Tax or Directorate of Income Tax. In the present case, the sanction has been accorded by Commissioner of Income Tax. Now, the last column is penalties, all penalties. And sanction order with greatest respect is not coming under the purview of penalty. Well, removal of service. He is referred to a lower post. That is undoubtedly coming under the purview of penalty. It is a sanction order against the prosecution. Now,
there is no defect in sanction order.
No defect. Now, so far the judgments, my lord, and here the learned public prosecutor already, if your lordship kindly see the second page of the impugn order, the same notification, the notification has been submitted. That is, my lord, inner page 2 of the order, last above the paragraph, my lord. Just your lordship escape the last paragraph, just above it. The learned PP CBI has referred to the notification number GSR 977 E dated 5/10/1988 to impress upon the court that the Commissioner of Income Tax is also an appointing authority in the case of Group B employee. Like the accused person, as such, there is nothing wrong with the competency of sanctioning authority in the case. And this circular just now I have annexed and I have shown to your lordship. The circular, the notification first page is at page 9 of the, my lord, my supplementary written notes of argument. The same circular, your lordship may examine. The same circular. In spite of that, he has not taken into account with greatest respect. Now,
other matter may be released.
Other matters may.
Your written notes of argument is there. Yes. No. Order has already been passed. No mentioning, madam. No, madam. Order has already been passed. No review of order. No.
Now, so far,
yes,
my lord, 19.2, your lordship, God, my lord, 19.2 of the Prevention of Corruption Act, I have handed over the book to your lordship. It states, where for any reason whatsoever, your lordship kindly takes my.
Yeah, you are referring which page?
My lord, Prevention of Corruption Act. Oh, your lordship is looking the supplementary written notes.
Yeah,
that is page 9. Your lordship may examine the same circular which has been referred by the learned PP.
This one.
Yes. Page 9. Supplementary written notes.
Supplementary written notes, page 9.
Yes. And the impugn order, my lord, page 2. Your lordship kindly. Same circular.
Yes.
The last page of the impugned order, I think. Same circular. Your Lordship got, my lord? That is the notification, GSR 977E.
Last page of impugned order.
Yes, last page. Just a minute, my lord.
Not at last.
Oh, no, not last page. First page. I stand correct. First page, that is just the paragraph above the last paragraph. Learned PP CBI, first page of the impugned order. Your Lordship got, my lord?
Learned PP CBI.
Yes, I'm however contended that Commissioner of Income Tax is also competent to accord sanction against the accused persons in terms of notification GSR 977E dated 5/10/88. This is the same circle. So that it is not that my learned friend Mr. Bhattacharya, senior, who is will be appearing in the next day, can argue that this was for the first time I am bringing this notice before your lordship. This was placed by the learned public prosecutor. It was not considered by the learned trial court. He is on that premise that appointing and removal is the same. Now, your lordship kindly once, my lord takes the Prevention of Corruption Act. I have given the book, your lordship kindly.
Yes.
19.2 of the.
You have already referred this.
Yes. My lord, once again, I am for my sake referring, my lord, wherein it has been categorically stated that where for any reason whatsoever any doubt arises to whether the previous sanction is required under subsection 1 should be given by the central government or the state government or any other authority, such sanction shall be given by that government or authority which would have been competent to remove the public servant. The word has been used in public, my lord, the prevention of corruption as the competent to remove, not the appointing authority or the removal authority. And here, so far the gazette notification is concerned, Commissioner of Income Tax is the competent person to remove the petition, and that has been done. As because also that at that material point of time he was working when the offense has been committed under the Commissioner of Income Tax. Now, so far the judgments are concerned, the lordship kindly takes my written notes of argument once.
Yes.
Written notes of arguments. Page 6.
Page 6.
Yes, that is the Supreme Court of India, Ashok Tisreng Bhutia versus State of, I have annexed, my lord, State of Sikkim. I will be taking your lordship to paragraph number 12 and 13. Just a minute, your lordship. That is at page 11. Pagination, page 11.
Yes.
May I please?
Yes, please.
Your lordship got, my lord?
Yes.
Same remained the position regarding sanction in the service again. In the absence of anything to show that any defect or irregularity therein caused a failure of justice, the plea is without substance. A failure of justice is irritable to error, omission or irregularity in the sanction. Therefore, a mere error, though I am admitting here is no error, even for assuming, for argument's sake, a mere error, omission or irregularity in sanction is not considered to be fatal unless it has resulted in a failure of justice or has been occasioned thereby. Section 19, subclause 1 of the PC Act 1988 is a matter of procedure and does not go to the root of the jurisdiction. And once the cognizance has been taken by the court under CRPC, it cannot be said that an invalid police report is the foundation of the jurisdiction of the court to take cognizance. Now the next para. And the two provisions there too shows that the next page. The investigation by the designated police officer was the rule and the investigation by an officer of a lower rank was an exception. It has been ruled by the court in several decisions that section A of the act was mandatory and not directory, and the investigation conducted in violation thereof bears the stamp of illegality. But that illegality committed in the course of an investigation does not affect the competence and the jurisdiction of the court for trial, and where the cognizance of case has been fact taken and the case has been proceeded into termination, the validity of the proceedings is not vitiated unless a miscarriage of justice has been caused as a result of the illegality in the investigation. Here in the present case, though competent was sanctioned by some other person, even, my lord, the Honorable Supreme Court has taken the view that it is not an illegality. Now the next judgment, my lord, in the same written notes of argument.
Lord, with all due respect, my lord, can it be continued the next day, my lord? Because there's a resolution by the bar.
Oh.
And we are members, my lord, of the bar, my lord.
Very well.
1 half.
Your Lordship, kindly
Parter.
fix any date after 17th.
Parter.
Parter, deeply obliged.
Let it be fixed on 21st November 2025.
No, time.
Time করবো না। Grateful. Lord. I will complete on the next day and
Parties are directed to come.
I will complete on the next day, and thereafter
Come
Mr.
prepare on
Bhattacharya
next
will-
day.
By Mr. Bhattacharya,
Yes.
we will argue there.
Yes.
Yes.
I'm deeply opposed. Deeply opposed.
Grateful.
Duck.
Deeply opposed.
For order has already been passed in open court. But no. No order can be recalled by in this manner. Your written notes of argument was there. I gone through with your written notes and
Lordship kindly gives us a last opportunity, Lordship. Lordship gives us one opportunity of hearing, Lordship. I'm kindly beseeching you, Lordship. I will communicate with the state. Lordship, I'm kindly requesting you, Lordship. I will communicate with the opposite party.
Very grateful, my lord. Very good. Very good.